Okay, we good? Alrighty. There's a couple of questions that were asked. Well, a couple of comments that were commented, and I want to do a dedicated episode kind of addressing these. So I'll kind of frame it, and then I'll let you go off because you'll have more of the information than I will. Two comments by the same person. First one says, the fact that so many cases just get rubber stamped at appeals council, yet federal finds all of these errors, very telling. From my own experience, there is intentional misconduct and mishandling of people's cases. And then they also commented on, I think, a different post. Well, I'll give a little bit of context. We were talking about trust the process. I think we did an episode that's just called Trust the Process.
Right.
And they commented and they said, unfortunately, I don't think some people can just trust the process if they want to survive to see their case approved. So there's two things I want to address in this episode. The first comment is about the federal cases. So I want to address what that even means, like hearing to appeals council to federal. And then what she's getting at is how is it that the appeals council denies almost every case, and then the federal will approve so many? Doesn't that just mean that the appeals council is not doing their job? Which is pretty much true, but we'll talk a little bit more about that. And then the whole trust the process bit, I want to break down what we don't mean when we say trust the process, because we don't mean you get a denial and then you just,
Oh, well, they told me.
I'm not denied then. Yeah. That's not what we mean.
Yeah.
We just mean, and again, I'll let you talk more about this, but when I think of trust the process, I think of when they send you a form, you fill it out. When you get denied, you file the appeal. And then when you're in the hearing, you don't argue with the judge about, Donald Trump during the hearing or something like that. That's trust the process, like go through the whole process. And you can think that it's ridiculous, but don't try to make up your own rules for while you're in the middle of the process. So we'll get into the whole trust the process bit, but real quick, just kind of recap. A client is denied a couple times. They make it to the hearing level, hearing in front of a judge. They get denied again, and then they go to the appeals council. Just pick it up from there, and then.
Okay.
Yep.
So I've said this before, and it's, I don't want to hurt anybody's feelings at the appeals council, but if I were commissioner for a day, I would abolish the appeals council. So
yeah.
if I hurt your feelings because you work at the appeals council, I do apologize to you. It's not anything personal. It's just statistically you are irrelevant. 14% of the cases, this stat's pretty much stayed the same also. 14% of the cases that are appealed to the appeals council are remanded. So the appeals council says, essentially, 85% of the decisions we say, we agree with the judge. The judge was right. They'll try to kind of spin that to where, well, the judge might not have done everything right, but overall, the errors that he made were called harmless errors, and that's a legal term that you never, ever want to encounter. It's not harmless error, or it is harmless error. And the appeals council will always say that, yeah, they made an error, but it's harmless error. So they still would have denied him, but so the error that they made is harmless. When it gets to the judge's decision, we go over it with a fine-tooth comb. I want to make sure that the judge did everything that they needed to do. And there's 5, I think, issues that you can bring up to the appeals council as the basis for an appeal. The judge was wrong because of the 2 that they actually look at is that there was an error of law, that they actually didn't follow their own rules, or that substantial evidence doesn't support their decision. Okay, well, they found this, but the bulk of the evidence says that it should be that. Those are the 2 reasons that we representatives get the most traction with. So, the process is we'll get a judge's decision, we'll look through it. Usually, my decision or my appeals are going to be on those 2 issues. There's an error of law, or the substantial evidence does not support the decision. I will say this, in the circuit that I'm in, that I live in, actually, we handle cases all over the country, but There are particular judges in the circuit that, in the state which in the area that I live in, that actually say something that is so telling, and I've seen it over and over and over again, that they will send a case back. These are federal magistrates, and I'm going to talk to you about federal court in a minute, but these are federal magistrates who have gotten a referral or a case from us through our attorney partners that we have file federal court cases, and we'll get the remand from federal court, and there will be comments in there like, once again, Social Security has failed to follow their own rules. And you see these kinds of incendiary comments like that, and as a representative, you're like, yeah, go get them. Wait a minute, I'm the one who's going to go get them. And but it happens over and over again, especially, like I said, in the circuit that I'm in. There are some judges in that circuit that just obviously they see a lot of the same mistakes made over and over, and they'll write something. Once again, Social Security won't follow their own rules. That's an error of law, and so that's one of the reasons that we send cases to them. But the mechanics of it, what it looks like is we have a hearing, and we make our case to the judge. The judge issues a decision. I disagree with that decision. My client disagrees with the decision, and I say, do you want me to appeal that to the appeals council, because that's the next level, it's level 4. Going to the appeals council, and it's a brief. You don't get to testify again. You don't get to show your face to the appeals council. They're so insulated that for us to even talk to a decision maker in the appeals council is some kind of blasphemy. It's like heresy. Don't you contact the appeals council. You just send them their brief. You sit on your hands and you wait for their decision, and it's going to come. 85% of the time, they're going to basically say, yeah, the judge was right. So that's what happens. So we do a brief, and we send it to the appeals council. And this person who wrote that must have some personal experience, because the term that I use 85% of the time is the appeals council rubber stamp the judge's decision. They don't address any of my appeal issues in their rubber stamp denial. And they basically say, this is the final decision of the Social Security Administration. If you don't like it, you can file in federal court. And we do. We have attorneys that we work with all over the country. There's several of them that we use. And we will basically say, hey, this is the case. This is why we believe the judge was wrong. This is why we definitely believe the appeals council should have remanded it or reversed it. Do you want to take the case? The vast majority of the cases we send them, they take. And they file in federal court, and you are exactly right, and this person is exactly right. The vast majority of those cases come back on remand. And why did I start this whole diatribe out by saying if I was commissioner for a day, I would abolish the appeals council? Because she's right. The vast majority of federal cases come back on remand. Keep in mind that when they come back, the path that they took to get to federal court, they got to come back the same path. So you have an administrative law judge who denies, the appeals council who upholds the denial. Federal court says, nope, that Social Security was wrong. We're not going to reverse, because they might not be disabled, but Social Security, missed the boat on this. We're sending it back. Does it go back to the judge? No, not yet. It goes back to the appeals council. It has to travel the same route that it went. So think about that. You at the appeals council have rubber stamped the judge's decision. And a few months later, you get a decision from federal court that says, there's no way you should have rubber stamped this judge's decision. This was an error. Some firms are running 70 to 80%.
Remand rate from federal?
70 to 80%.
Yep.
If it was 50%, by the way, we do, with our attorney partners, we do about 70. But if it was as low as 50, if half the cases that we send up there were remanded, that basically, federal court says, no, Social Security was wrong. Think about that. 85% of the appeals council cases, rubber stamped. And then it comes back a few months later from federal court. And you would think after this happens for years and years and decades that the appeals council would that they wouldn't be rubber stamping 85% of cases that they get, they'd actually be, okay, well, we got to tighten this up. You would think that would happen eventually. Let me tell you that in my business, if my employees were wrong 85% of the time, or if they were issuing a decision 85% of the time, and then some higher authority said, you guys are wrong 50% of the time, okay, you guys need to tighten it up. Obviously, you're doing something wrong. And if they didn't tighten it up, I would fire them. That's why if I was commissioner for a day, I would abolish the appeals council, because they've had decades upon decades upon decades of these federal court cases coming back at them and saying things like Social Security won't follow their own rules. And it's still 85%. We're still going to rubber stamp them. And it just, I've obviously you can tell because my face is probably beet red right now, that it really bothers me. I have a case right now that, I'm going to win it. I know I'm going to win it. I'm probably going to have to win it with federal court just reversing it. And that happens too. Federal court's like, there's no reason to remand this. The decision was so unsupported, was so obviously wrong, that we're not going to put the client through another year or year and a half. Because when they remand it, guess what? It takes a long time to back trace through that path that it took to get to federal court. I'm not going to wait. I'm not going to make this disabled person wait another 12, 18 months to get a hearing with the same judge who has already missed the boat. And so they'll reverse it. But why? Why should we have to jump through those kinds of hoops? What's going on? And then addressing what this person says with, I believe that they're intentionally doing this kind of thing. Well, I've said this, and I'll stand by it. I believe that the Social Security Administration, the brass in Social Security Administration, by the way, you guys need to realize that the brass, basically the top folks in Social Security, not the commissioner, because the commissioner usually serves at the leisure of, or the pleasure of, the president. But there are people who've been in Social Security for 30 years, that they're in upper levels of employment with the Social Security Administration, and they survive administration changes. They're just there for a long, long time. I do believe that the brass in Social Security, for whatever reason, believe that the Social Security Administration, which the Congress has mismanaged that fund for as long as I've been alive. I'm 60. So for 60 years, the Congress has mismanaged the so-called trust fund. And the way they're going to save Social Security is on the backs of the disabled. They're not going to do it for retirees, because retirees vote. But the disabled, a lot of times they don't have a fixed location. They're transient. They're having difficulties, with stability in their life. They're not going to vote, some of them are, but a lot of them aren't going to vote. And if they're not going to vote, that's who we can, that's who we can use. That's who we can scapegoat to show that the Social Security Administration is spending too much money. Is it spending money because of fraud? Well, they've done studies on that, and there's really, I think the last study was like 3%. Good luck finding that low of a fraud statistic in any government agency that handles billions and billions of dollars. Good luck with that. Try that with the VA. Try that with the Department of Defense. Good luck with that. So it's not fraud. What is it? Well, if the Congress has been pilfering money for the last 5 decades, there's really only one way to get that money back, and that's to tax the people that you stole the money from. And they're not going to do that because they'd be elected out of office. But if they can scapegoat the disabled, and we can't allow so many cases. Well, what if this person's really disabled? Shut up. We don't care if they're really disabled or not. We're not going to allow so many cases. And I've talked to judges about this. I've talked to our attorney partners about this. I've been doing this. I started my practice 22 years ago. I've been doing this for 35 years. In the last 10 years, I have seen 0 law changes that were favorable to the claimant. Zero. When they change laws, and they do it a lot, by the way, it is always, okay, we're going to make it harder on the claimant to prove disability. We're going to require something from them that it's going to be onerous. It's going to be hard for them. We're going to change the law. We're going to change the listing to where, you used to have to only prove this, but now we're going to make it to where you have to prove this and this and this and this.
Yeah.
And that has happened in the last 10 years. I can't name you one law that they've changed or ruling. It's usually an SSR, a Social Security ruling. I can't name you one in the past 10 years that has been favorable to the claimant or favorable to the process. We're going to make it easier, really? You're going to make it easier?
Yeah.
So, yeah, just basically an overview of what I'm saying. She's right. I wish she was wrong, but she's right. The appeals council, I don't believe they justify their existence. And of course, that sounds really hard for me to say. But being a former government employee, the government has to do studies every once in a while to justify certain positions. They justify the number of positions that they have, and they justify the position being, necessary to fulfill some kind of work obligation. If you are rubber stamping 85% of the decisions that come across your desk, I can look you in the eyeball, and it'll probably make you cry or make you cringe or make you angry, but I can look you in the eyeball and say, your position is not justified. If you're rubber stamping, you're not needed. If basically your job is to give a smile and a thumbs up to a judge's decision, almost 9 out of 10 times. Sorry, you can't justify your position. And that's why I'm so harsh on the appeals council.
Yeah, I mean, if you compare this kind of structure to how a private company in like a free market would work, it's very simple. You have a company, you have employees. If those employees are doing really bad work and therefore they're losing your company money, you do something about it. If they don't change, you fire them. That's
right.
Obviously, hey, you're actually losing the company money. You're doing a horrible job, so you're fired.
Right.
With government, they get a remand, or they get, the federal court says that they made a horrible decision 85% of the time. They don't even say sorry because they don't need to, because there's no accountability. What's going to happen?
Yeah,
they kind of just shrug, or they don't shrug because you don't even know who they are.
Yeah. You usually have a name of the officer. It's an appeals officer. You have the name, but it's a huge organization. They're centrally located. They're they're in D.C. suburbia in Falls Church, Virginia. You can't call an appeals officer. You certainly better not call an administrative law judge that works for the appeals council. I mean, ALJs are about as insulated can get, probably more so than a Supreme Court justice.
Yeah.
But you can't call them, you can't discuss things with them. Their decisions are final, and you're exactly right. I would just wonder what kind of employee review they get. Okay, well, you've towed the party line very well. You have rubber stamped 85 of the decisions that have come across your desk. But, 70% of those decisions have come back on remand. So we got to talk about that. I would wonder how many times that happens. And my guess would be none.
It doesn't seem like it.
None.
Yeah.
Yeah. I mean, if the continuing outcome is the same, you have to assume that nothing's being done. They don't care that federal district court, says things like Social Security, once again, isn't following their own rules. You don't care about that. I would care about that. Disability consulting, once again, is providing, inaccurate information to Social Security. Not only would I care about that, I'd probably be in big trouble with the Social Security Administration. But you don't see that in the appeals council. They're so insulated. And let me just make a disclaimer. I'll look in the camera on this one. I'll make a disclaimer. This is Carl's opinion, okay? Yes, I have some very, very harsh opinions of this entity, But it's just my opinion. I can't say that it's shared with representatives across the nation. I think it is, but I can't say that. It's just an opinion that I have. And again, if you work for the Appeals Council, you can feel safe because I don't have any power whatsoever to remove you from the job or to abolish the agency. But I would if I could.
Yeah. Okay. And then lastly, just addressing, kind of to tie a bow on that, what she asked about trusting, well, not, they're not questions. I keep calling them questions. but
Trusting
they're
the
really
process, yeah.
yeah. With all of that being said, because it's easy to hear about all that and then just want to flip a table and say, screw it then.
Yeah.
But you can't really do that. You still actually have to work inside their rules of how the process works.
Yeah. People who've been watching the podcast, especially the one that we're doing right now, you can tell that I have very little respect for certain entities in the process. But believe it or not, administrative law judges, they're not in that list. I actually enjoy interacting with the judges. I believe that the vast majority of them want to make a great decision. And sometimes that great decision is a denial. And I don't think that they are like the Appeals Council. I don't think that they're just, for the most part, that they're looking for a reason to deny. The lower levels, I don't believe the lower levels are necessarily looking for a reason to deny. I do believe that, at least from my experience when I worked there, we were trained to deny first and then, consider an allowance later. And I think that's going on in a lot of the lower levels, initial and reconsideration levels. But trusting the process does not mean, we're not saying that means trust the Social Security Administration. As a representative, I am at odds with the Social Security Administration after they've denied my case or my client's case the first time until I win the case. I am at odds with them. I believe that they're wrong. I believe most of the time that their decisions are based on a faulty premise, or they didn't have the right information, or they didn't consider the information that they should have, or they weighed a certain information higher than they should have, or they weighed certain information lower than they should have. I am at odds with them after they have denied my client. So I'm not saying that you need to trust Social Security, but the process is successful for millions and millions of people, and the process does involve you being cooperative. If you are so down on Social Security that, forget them. I'm not going to fill out this stinking form, Why don't they believe me? I've been paying my taxes for 40 years. You get that attitude, and although I understand it, I certainly understand it if you're going through the disability process, because it probably means you're at one of the lowest points in your life. You can't work, and you don't feel as useful as you used to feel, and health-wise, you don't feel good. You just, you don't feel good. I get that, but you have to trust that the way that the process has been set up, that eventually you can convince Social Security that you are disabled. You can fill out the forms, even though you don't want to. You can tell them about your past work. Why do I have to describe what an over-the-road truck driver does? They should know that. No, you got to describe it. Sorry, it's part of the form. You got to fill it out. Why do they want to know if I'm able to feed my cat? Yeah, I can feed my cat. Wrong. You got to write down you can feed your cat. Do you always remember to feed your cat? Well, no. Sometimes my wife has to remind me. Write that down. That's important to your case, especially if you got some mental problems. The process. I got to send this stuff in timely. Why are they only giving me a couple weeks to do this? Because the Congress has told them a disability claimant needs to get a decision in a reasonable time frame. Now, the definition of reasonable changes year to year. When I first started out, I think I've told you guys, when I first started out, the wait for a hearing was 28 to 32 months. That's not happening anymore, thank God. But the length of time can change. This is reasonable. If they have to wait 8 months, that's reasonable. No, it used to not be so reasonable. You know, initial cases used to get decided in 4 months, and now it's taken about 8 months. What what's reasonable now?
Yeah.
You know, 10 years ago it wasn't reasonable anyway. But it's because you have to turn your stuff in timely because the Congress or the Social Security Administration themselves have realized that they are expected to do their job in a certain reasonable time frame, and that that goalpost shifts quite a bit, but there's nothing we can do about that. The process with us, having a representative. A lot of people believe I have a representative. I'm going to go to Barbados and call me when you win my case. Well, I don't want you as a client if that's your philosophy on how you're going to cooperate with the case. We're a partner. We're in a partnership, and I need you to cooperate with me. I need you to tell me about any kind of medical treatment that you have, if it changes, if your medication changes, if you move, please let me know you moved. If you change phone number, please let me know you changed your phone number. I'll get all that information to Social Security. But Social Security expects you to report changes. If you go to work, don't be afraid to call me because you've gone to work and Aunt Betty, or Uncle Ben told you, hey, don't tell them that you've gone to work because, that'll mess up your case. Okay, please listen to somebody with expertise, me, not Aunt Betty and not Uncle Ben, who somehow got approved, or, the third cousin on their father's side got approved, and therefore they're experts in the process. No, I'm the expert in the process, so trust it. If I ask you to report to me that you go to work, I'm not trying to screw up your case. By the way, I don't get a dime if I screw up your case. I have to win your case to be paid. I have to win your case. I've got a vested interest for everything that you do helps your case, and everything that I do helps your case. So please trust the process with us, and then trust the process with your medical providers. We've said this before, with very few exceptions: a learning disorder, autism, some impairments that just don't respond to any kind of medication or therapy. Other than those kinds of impairments, Social Security and Disability Consulting expect you to be in ongoing treatment. Why? Because if your condition is so bad that you can't make it through an 8-hour workday or 40-hour work week, I expect to see that there's some medical records that show your condition is so bad that you can't make it through an 8-hour workday, much less a 40-hour work week. It doesn't make sense to me that you have a horrible, ridiculously painful condition that I haven't seen a doctor for in 2 years. Is it really that bad? Can you convince Social Security that it's really, really that bad if you haven't seen somebody in 2 years? Well, you don't have any money. Is it really so bad that you haven't gone to the health department and begged them for some help because your pain is so bad? No, Okay, what are you taking? Well, I take hot baths. Well, we take any medication? No. But I have to convince Social Security that your condition is so bad you haven't seen anybody in a couple of years and you're not taking any medication. If I came to you and told you that, do you think that's reasonable?
Yeah.
No, you wouldn't think that's reasonable. It must not be that bad. You're not seeing anybody or taking any medication for it. Okay? So trusting the process is when we tell you, and your case manager with our company is going to remind you, need to make sure you're faithful with treatment. If you can't afford, a specialist or a regular doctor, you can go to a health department and just report to them what's going on. Are they going to give you the kind of care that you would expect, a PCP or somebody that you're paying to give? No. But it's still going to show up as medical treatment, and that's going to help us make the case. So that's part of the process too. But yeah, don't think that when we say trust the process, we're saying trust Social Security. I'm at odds with them. At the very beginning, I'm not at odds with them because they haven't denied you yet. But when they deny your case, now I'm at odds with them until I get your case approved. So
Yeah.
I'm not saying trust Social Security, I am saying trust us and trust the process. That that's just it's the rules. It's basically like if you were playing any kind of sport. If you ignored the rules, okay, you'd probably be disqualified, or you'd be really horrible at the sport. Same thing in this, the rules of Social Security, going through this, cooperating with them, blah, 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 all the rules. You have to follow them. Sometimes they're not fun to follow. Sometimes they're tedious, but it's the rules. And there's really no other part of your life that I believe that you would have such an angry reaction to that. They want me to fill out a form, or they don't believe that I'm disabled. They're making me prove it. If anybody else, was interacting with you on you telling them something that, you have to prove, you wouldn't get angry with them for them to say, "Oh, really? Well, why? Give me some proof of why you think you're disabled. Give me some, cooperate with the system so I can see what's actually going on with you. Cooperate, trust the process. Not saying trust Social Security, but trust the process."
Yeah, the idea of trust the process, for me at least, has become a lot less philosophical in the past couple of months and a lot more data driven. Because the data that you and I have been going through in the past couple of years of seeing of all the cases we closed, or of all the cases we signed, how many are closed, like we closed the case, and if they're closed, why do we close them?
Right.
And to me now we have a pretty good metrics on what we even mean by trust the process, because it's amazing, and not in a good way. It's amazing in a bad way that we actually close more cases, or I'll put it this way. The main reason that we close cases is not because we get a denial and then we don't appeal it. It's because of all these other reasons.
Yeah.
And all of those other reasons fall into the category of the client not trusting the process.
Yeah.
So this would be, they get a piece of mail and they don't fill it out. So they get a denial before their case is even put online because they just won't fill out a form.
Yeah.
Or after that, maybe they fill out the form, but at some point we just lose contact. We just never hear from them again. So we don't know, maybe we get a denial, but we can't appeal it without talking to them.
Right.
And then one that's really unfortunate, they hire us and we tell them how long it takes and we prepare them for how long it takes, and they can see public data of how long it takes. But then 2 or 3 months goes by and they dismiss us because we haven't gotten them approved yet, and they go hire someone else.
Yeah.
And they hire someone else, and it's going to take the
Yeah, that's
exact
right.
same amount of time.
Yeah.
Or we have to withdraw from a case because they just lied to us about something. Whether it's earnings, or, well, it could be anything, earnings or substance abuse or a combination of all of these things. They just blatantly lied about us, and we can't do anything with the case because they've lied to us so many times.
Right.
All of those reasons that we close cases are due to the client just not trusting the process. If you actually fill out the forms, you can complain about, why do I have to fill? Okay, but you still got to fill it out.
Right.
Fill out the form. If you change your phone number, you got to let us know. If we email you or text you or call you, like, you got to work with us here. If we ask you if you're working, please tell us the truth and don't lie to us. And if the client will go through that whole process, they have an extremely high chance of approval eventually. It's not going to be guaranteed the initial application.
Right.
Like we were just talking about, we might have to take it to a federal case and then get it remanded, and we agree on how absolutely absurd that is. But that is within the process.
Yeah.
And we can't do that if we call you and you don't pick up the phone, and then we try to call you again, and then we've been trying to contact you for 5 months, and we don't even know, are you working now, or are you living in the same state? Are you even alive? We don't know what's going on here.
It is incredibly disappointing, disheartening to close out a case without getting to make a medical argument. And if you have fallen off the planet, you changed phones, you couldn't afford the phone plan anymore, so you had to get a minutes phone, or you moved because you couldn't afford the rent anymore. But you never told us. We just lose contact with you. And that decision gets made, and we didn't get to make a medical argument. It gives me a pit in my stomach, because really, you didn't have a chance. You didn't even have a chance. If I can't make, they're disabled because of this and this and this, No, they're disabled. They didn't turn in the forms. What do you mean they didn't turn in the forms? Yeah, we're not going to assess their case without them turning in the forms. Oh, wow. Okay. We don't get to make a medical argument. Nope. Nope. Okay. Well, we get to this level, we get to that level, and we haven't spoken with you in 6 months. And we really believe in your case. We believe in your case so much that we're still going to present your hearing without you. And I have done that far too many times. And the judge, kind of makes a joke at the beginning of the hearing. So, Mr. Groves, you look kind of lonely today. Yeah, I don't have a client. They're out there somewhere. I just haven't spoken with them in 7 months. And I will try to make an argument, but they're just going to dismiss the case. You didn't show up for your hearing, And then, I won't say invariably, but more times than not, boom, they pop up 3 or 4 months after a denial, or 3 or 4 months after a hearing that's been dismissed, or 3 or 4 months after they failed to attest their case that never even got launched because they didn't literally sign a page and send it back. Hey, how's my case going?
Yeah.
What case? What do you mean? And then I'll explain to him, you dropped off the face of the planet, you didn't cooperate, you didn't trust the process, didn't trust us apparently because you never called me. You get to start all over. What? That's right, yeah. You get to start all over because you just didn't, once again, you didn't play by the rules. They gave you rules. They're tedious rules, but they're not ridiculous rules, and you didn't play by them. And guess what? You didn't avoid it by not filling out the form. You didn't avoid it one bit. You just lost all that money on all that back pay that you would have gotten if you did it timely, because now you're starting again and you've lost all those months. And if you want to win still, guess what? You got to do it still. You still got to fill out the forms.
Yeah,
you
you
still
can't-
have to attest your case.
Can't get around it.
You still get to do it. Now, you've lost 7, 8, 10, 12 months. You've lost that because you decided you weren't going to cooperate and you didn't trust the process and you didn't trust us. So you get to start all over. And depending on how horribly you didn't trust us, I may not take your case. You can try somebody down the road. Maybe they'll put up with you not reporting an address change, not going into treatment, not filling out forms, not reporting a phone change, not checking in with me every 2 or 3 weeks. Maybe they're okay with that. Good luck with that. But there's a good chance, if I have spent a lot of time and paid my employees, I got to pay them to process your case, to go through the process, and you're just not cooperating. You're not really involved. I don't know if I'm going to do that again. I don't think I'd want to go down that road. It's one of the, fool me once, shame on you, fool me twice, shame on me. It's one of those situations.
Yeah, and it's always something mundane, isn't it? Where it's like they'll call you, you'll get a call, you'll pick up the phone, they're like, "Hey, do you have any update on my case?"
Yeah.
It's like, the update on your case is that we've called you multiple times a week for the past 6 months,
Yeah.
and your case is closed. There is no case. And they're like, "What?" It's always something like
happens
that.
all the time. I had a hearing this week, and I hadn't talked to my client since July. So, depending on when you're watching this, I'll just tell you, that's 7 months ago. So, hadn't talked to this guy in 7 months. Sure enough, a hearing was scheduled, and the hearing went forward because, well, it just did. It went forward, and he shows up. And so he had changed phone numbers, but he was living in the same place. So he shows up to the hearing, and the judge is asking, can you tell me your social security number, tell me your date of birth, what's your address? And when she was asking that to him, I'm sitting there, okay, where did he move to and why didn't he report it? And it's the address that we have. And then it dawned on me, we'd sent him 8 letters to that address. Since July. For 7 months, I'd sent him 8 letters. Please call me. You have a hearing scheduled. We need to talk about your hearing. And he ghosted me. And then just picks up immediately on the phone when he had the hearing. And his testimony was so unbelievably bad that I'm like, there's nothing I can do with this case. I literally I don't think I can. I don't think I can pull him out of the hole he's digging for himself. Talking to this judge, he literally basically testified he didn't have any problems standing or walking. He didn't have any problems lifting anything. He didn't have any problems concentrating. And I'm sitting there.
Yeah, then what are we doing here?
Why did he apply for disability if this was his testimony? And it was all wrong. I mean, he did have those problems. When we talked to him, when we first took the case and up to July, the last time we spoke to him in July, up to that point, I'm having some problems here. We had updated his treatment in July, and so we got medical records, and they were pretty current. And the medical records showed some things, but his testimony essentially gave no limitations whatsoever in any aspect. And I'm thinking to myself, the judge is going to deny this. She can't do anything other than deny this. I can't spin it. I can't send an appeal that said, we appeal this for the reason that my client ghosted me for 7 months, and if they would have stayed in contact, they would have known that their testimony is garbage. That's not a good appeal reason, and there's nothing I can do. And think about that. We've told people this in prior podcasts. When you go in front of a judge and the judge issues that decision, and once that decision becomes final, it might as well be written in stone. So if this client, if he goes back at a later date to apply for disability, and he says he became disabled in 2021, which he did, you can't do that now. Judge's decision is going to be in 2026. The furthest back he can go is going to be 2026. You can't go back in a judge's decision. And why? Just because he didn't trust the process. He apparently didn't trust us because he didn't stay in contact with us. He absolutely 100% got 8 letters from us begging him to call because you have a hearing scheduled and we need to talk about it. And you're not answering text, you're not answering emails, and you're not answering the phone. And then he picks right up for the judge in the hearing, pretends like nothing's happened, and it's going to go so poorly for him.
Yeah. Well, I think that's a good place to end it.
Yep.
Like I said, we did a whole podcast about trust the process, but I guess we do need to clarify. Like we're not saying trust Social Security's decisions, because that's like the whole reason we have a company is we don't believe their decisions.
That's my reason for being.
Yeah, but trust the process. Like when they send you a form, you got to fill it out.
Right.
You can't just disagree with filling out the form and then act like nothing happened. Like, you got to play by their rules.
Yeah. Or I filled this out 8 months ago. You probably did, and you're at the reconsideration level. And guess what? They want to know now what's going on. So, got to fill it out.
Fill it out again.
Yep. Sorry,
Yep.
you have to.
Okay. Scene. If you have a question about your disability case, drop it in the comment section below, and we will do our best to answer it in the next episode.